And where are we on this case, folks?
Your Honor, we've had a few hearings on this. The court had set this for a trial at this point based on the affirmative defenses that were asserted in the matter. I believe there's no triable issue. If you look at the answer filed by Ms. Kinkley in the matter, she admits to the non-payment of rent. She admits to the fact that there are damages to the unit. The court is aware there were police reports filed and attached with the complaint that the damages were the result of the defendant herself breaking the windows, refusing access. The landlord is now going to be outside of the certificate of occupancy that was issued because repairs can't be made. They can't get access to the property. It continues to deteriorate. As a result, there's a broken window, broken doors on the interior, broken doors on the exterior. We filed a notice to have this terminated as a result of the health and safety hazard as well as the non-payment of rent, and we'd be asking for a judgment at this time.
Response.
I have it prepared here. I will pull it up.
There is a tree to me.
Okay, this was what I received from attorney with the legal aid, Tracy Jensen. And there are several issues at hand, including procedural defenses. In regards to my written statement and the statements made by Attorney Babnick, the property is not damaged. The pictures that the landlord included, I have countered and included pictures of the house in its current condition. The house was inspected by the Ypsilanti Building Code, Miss Jamaica Berry, in October. In October, I also filed a formal complaint with the city of Ypsilanti through the C-Click Fix notification system, a governmental agency, of the issues with the habitability of the home. I have filed a case with the Fair Housing Administration. There are many things that we could focus on. I would like to focus on the fact that I was denied a disabled parking spot. And according to Michigan Legislature Section 600, and that is 600.5720, says that if it's an alleged termination was intended primarily as a penalty for the defendant's attempt to secure or enforce rights under the lease or agreement or under laws of state, governmental subdivision, or United States, they denied my handicap parking. I filed several complaints at the city level, and I'm defending myself here. The alleged termination, Part B, was intended primarily as a penalty for the defendant's complaint to the governmental authority with a report of the plaintiff's violation of the health or safety code or ordinance. The allegations made by the landlord, I wanted to bring in a third-party perspective. So I contacted the Ypsilanti Building Code Department. Ms. Jamaica came out and did an inspection and found 12 violations on the landlord's, at the landlord's responsibility. In regards to the statement by Attorney Babnick that they have not been allowed to access the unit, that is so false. Her husband, Mitch Carrick, busted down the door, and I was not able to secure the unit.
This isn't the time for me to receive.
I think there are tribal issues, and I can.
Thank you.
Yes,
that's
sir.
all you needed to tell me. And when I look at that, then what I'm going to do is I'm going to do two things today. I'm going to set it for a final settlement conference on this. We'll hash out specifically what issues are going to be litigated. The parties are going to need to be ready to go to trial when I set the trial date at thereafter. All right. I'm also going to order regarding escrow, and I'm just going to say this to you, Ms. Kinkley, that you coming into court and posting escrow in $1 bills, this court views as just harassing my clerks and making my clerks go through that process. It is something that I'm not going to tolerate. There is no reason why you have to bring single dollar bills in. You did that when you paid the $111.11. You also did that when you paid $444.44, which my clerks had to count out. You also did that when you paid today the $666.66. So on my own motion, I'm going to order that as you post escrow, that you may only post escrow in denominations of US currency, not less than $10 bills. It is further ordered that from you on this case, because of your abuse of the process, and my clerk's office are ordered that they are ordered to accept no $1 or $5 denominations of US currency for you for the purposes of escrow. And I have signed that order. We will present that to both parties. See everybody on March 19th.
Quickly, can the court, what's the registry of the court as far as the escrows?
There is a $111.11 posted by our records. It was posted on January 8th, 2024. On January 10th, 2024, there was posted $780. On January 22nd, 2024, there was posted $1.11. On February 5th, 2024, there was posted $444.44. And I think today, correct?
Yes.
Today, there was posted $666.66.
If I may, Your Honor,
Go ahead.
I just want to establish that I paid the full amount through February and there is a balance ready for March. This is not an issue of paying the rent.
My issue isn't with whether or not you pay rent. It isn't anything like that. Will not be trying to bring singles in, trying to make some point to my clerks. They have nothing to do with whatever the issues are here. They are here trying to serve the public. You will not hand them $600 worth of $1 bills for them to count out. It just won't happen. And I've issued that order.
Would you like any response to that, or we can just move forward?
You can make whatever response you want. I'm just telling you, don't bring any singles in here trying to post escrow. Don't bring any $5 bills trying to post escrow. $10 or higher.
Understood.
That's it.
Going forward, Your Honor.
Is there an adjourned date, Your Honor? I'm sorry, I didn't hear.
March 19th, 2024, 9 a.m. in person.
Your Honor, if I may continue,
Thank you, Your Honor.
if I may.
Go ahead.
Right, so I did confirm with the clerk that all US accepted. Policy does not-
No longer on this case.
Yes,
That is my order. Thank you. I'm done.
We are done. Thank you, Your Honor. I understand. March 19th at what time?
9 a.m.
Thank you, Your Honor. Have a wonderful afternoon.
I will do. You do the same.
I will do my best. I am grateful.
How are you, sir? What's your name?
Carol.
Emily didn't want your case called either.
Yeah.
No, I don't know. I don't know what that's about. I don't know what you did to her.
One of my old attorneys, Fred McDonald's told me don't pay nobody $1 bills.
Fred McDonald was my former partner. Yes. sir.
About money paid.
All right, where are we on this case?
Your Honor, I'm pleased to report Mr. Robertson and I met and we've agreed to a conditional dismissal in this case. Rent to return in the amount of $25.48, court costs of $160. That number, by the way, is through the end of March.
Okay.
$160 in court costs for a total of $27.08. Mr. Robertson's going to pay $25.58 by March 4th and the balance of $160 by April 5th. I did explain to him that partial payment would stay an issue for writ, and we went over MCR 4.201J.
Okay.
Only thing I want to change, your daddy, Your Honor, I'm on fixed income. And if the money don't come on the 4th, I want to make sure that I can pay it on the 5th. Instead of that being the 4th, the 5th.
So
That's fine with us.
So you want this changed to March 5th?
Yeah, yes, March 5th.
So when does your check come in?
So I get one on the 1st and one the 3rd.
Got it.
Yeah.
Okay, so it's that
Yeah,
that first payment.
correct.
No problem with changing it to the.
No, sir.
All right. I'm gonna make that correction. Anything else, sir?
No,
All
I
right.
just want to pay him in $1 bill.
Please don't.
Okay.
You don't understand what a sore spot that is. All right.
You guys should be disinfect the $1 bills. I'm telling what.
No, I mean, I didn't have to count it. So
Okay.
I had a whole lot of people telling me they did.
Okay.
So, all right. So, sir, any other questions you have regarding
No,
this?
and
condition?
that last payment for the 160 supposed to be when?
Yeah, that's April 5th,
April 4,
which will be that
5,
Friday.
or
Yeah,
1.
so it's March 5th and April 5th.
Okay.
So it's 160.
Okay.
All right. You have 3 business days to think about this from the date of my signing. If you believe that there's some legal reason, some confusion as to your rights or some right you haven't asserted, you'd have to file a motion with the court within that time frame to set this aside. Do you understand that, sir?
Okay, then that's 3 working days. That would be like
3 business days.
3 business. Okay.
I don't think you should be filing it, but you
Okay.
do have that option. Doesn't mean that I'd grant that motion.
All right. Then.
Understand that? All right. Thank you. I'll mark this conditionally dismissed. Thank you.
Thank you.
This transcript covers a landlord-tenant dispute where non-payment of rent, property damage, and habitability issues are central. The landlord claims the tenant caused damage to the unit, broken windows, interior and exterior doors and sights. Police reports. They are requesting a judgment and termination of the lease due to both non-payment and health and safety hazards. The tenant, however, disputes these claims, presenting counter-evidence, including photos, building inspection reports, and complaints filed with the city and the Fair Housing Administration. The tenant also highlights being denied a disabled parking spot, arguing that the landlord's actions are retaliatory under Michigan law. A third-party inspection conferred multiple code violations, supporting the tenant's position. The court also addressed procedural issues, particularly the tenant posting escrow payments in small denominations, $1 and $5 bills, which the court deemed harassing to clerks and ordered all future payments to be in $10 bills or higher. Finally, the parties agreed on a conditional dismissal with specific payment deadlines, a total of $2,708, including rent and court costs, with payments scheduled for March 5th and April 5th. The court clarified that any disputes regarding this settlement must be filed within 3 business days. Overall, this case demonstrates a mix of legal, procedural, and habitability issues, with both parties presenting evidence and the court carefully setting boundaries and deadlines for resolution.